I'm Shamik Dutta. I'm a solicitor at Bhatt Solicitors, and I specialise in data protection and claims against the state arising from breach of privacy. So I think we should start off by thinking about exactly what these revelations of Edward Snowden say. And what they say is that at the moment we're in a time where there is a complete breach of privacy in relation to every aspect of an individual's personality, simply because of the information that we would ordinarily exchange over the internet, and therefore what access that allows the state to have. It's not just access to communications, it's about access to someone's complete personality. So your political beliefs, your sexual orientation, your activities, and your familial relationships, and also sensitive information in relation to medical conditions. Anything like that which you would exchange with someone else over the internet is now fair game as a result of these. And so the laws that were established have not caught up with technologies that now exist. And we have a situation where you have an almost complete lack of privacy in relation to even the most sensitive personal information about you. Now, what that means is two things. First of all, we should be concerned about what the state intends to do with this information. And secondly, we should be concerned about what impact that has on us as individuals and our ability to freely communicate with each other. In the first instance, in relation to the impact it has on the state will have carte blanche to do whatever it wants with this information, and it could be very wide-ranging. For example, cataloguing individuals who've got certain political opinions into certain groupings for a particular type of database, deciding to further monitor other individuals who are on the database because of certain information that's been exchanged, however innocently, over the internet. So those are two kind of issues that you should think about in terms of what the state can do. But also, another issue is the impact it has on us. You know, are we going to freely communicate with each other in the same way that we always have, in a way that's necessary for there to be any kind of human progress in terms of ideas and society as a whole? If we feel that everything we're saying is being monitored, there will necessarily be a degree of self-censorship where people aren't willing to exchange ideas freely if they think it could be interpreted as something which is a challenge to current orthodoxy or the way in which things are generally done by the state. And so those are the two main concerns that I think I've got about the revelations. So, I mean, I suppose there's three main cases that I could talk about that I've been involved in and what I think they mean. The first is the case of GC, which concerned the retention indefinitely of DNA samples and DNA profiles and fingerprints from people who'd been arrested but not charged with any offence. Most of those people had real concerns that their DNA sample contains a vast amount of information about them, information which the police, in trying to solve crimes, wouldn't need in any event. For example, who their real mum is or who their real dad is, whether they're adopted or not, whether they've got a propensity to suffer from certain types of ailments. You know, things like that are what are contained in your DNA sample, and it's information that there's no reasonable police officer would need in any event, even if someone had committed an offence. The second is the stigmatisation that people felt that they were arrested and that their information is retained, really sensitive information about them, where they've never been convicted of any offence. And that obviously leads to people feeling as if they're being targeted even when they've done nothing wrong. And quite often, when it comes to targeting, which you'd mentioned there, one of the things a lot of the people who approached me were concerned about was that, and this is particularly young black and minority ethnic men who were disproportionately on the DNA database, it was that they felt in some cases that they had been arrested on trumped-up charges simply in order for the state to gather their DNA sample and their fingerprints. And then they were released without charge. Now, in those circumstances, you can see the impact that has on a certain section of society's relationship with the state and whether it considers the state to be a body which is there to protect them and to ensure that their rights are protected or whether they feel targeted by that state. So those are the issues arising from the DNA database case. Another case which I've worked on, the case of John Catt, concerns an 89-year-old peaceful protester who is being monitored by the police, and the police have got reams and reams of data about him on what's called a domestic extremism database. Now, he's never been convicted of any offence, let alone a serious one. He's 89 years old, he goes to protests, he sketches the scene, and he goes home. But the police said that it was necessary for them to catalogue his information. One of the reasons was because he doesn't do anything wrong, so that then they can identify people at a protest who are not going to cause them any trouble. Now, you wonder, I mean, both of these cases kind of show me that over recent years, the state has been involved in this country in a data grab, in trying to gather as much information as possible about all of us, because in their view, if they know everything about you, it will make their job a lot easier in identifying what kind of person you are, whether you're a help to the current status quo, whether you're a threat to that status quo because of the ideas you might exchange. And this really comes from a position where we haven't really, as individuals, come to terms with how valuable our personal information is, and where the value of that information isn't properly reflected in any way, either in law or financially or any other way. You can expect a state that wants to have the easiest job possible to try and gather as much information about us as it can. And so that's what those two cases in particular, I think, have shown me. And the third case is obviously the case that we're pursuing against the security services arising from Edward Snowden's revelations. Mm-hmm. And really, the third case is an indication of, well, it's evidence that the kind of suspicions that many of us have arising from the first two cases are actually true, that the state is involved in a mass data grab and is exploiting the fact that there aren't adequate legal protections and there isn't sufficient value accorded to personal information. So the case is challenging the security services' interception of communications data and the retention of that data seemingly indefinitely. It's challenging the fact that it happens, and it's challenging the regime which allows it to happen. And that's not just in relation to the legal safeguards, but also an examination of whether the court, the Investigatory Powers Tribunal, is really sufficient to be able to have this supervisory function over the security services. And in our view, the Investigatory Powers Tribunal has never sufficiently protected us from this kind of thing happening. Secondly, the laws, as they currently stand, were never written with this type of technology in mind, and therefore what is happening now, as revealed by Snowden, is not in accordance with the law. And that's a very important requirement that any such law needs to satisfy if it's to comply with the Human Rights Act. And so what we're trying to do is to challenge its operation, to cease its operation, and hopefully trigger a debate in a position where everybody is fully informed as to exactly what is happening, why it's happening, and whether or not it's necessary.
One of the problems with the Investigatory Powers Tribunal is that most of the judgments, or all of the hearings and most of the judgments are secret. So
yeah.
We have no idea as citizens of this country what body of case law has been developed, which may even facilitate this kind of operations. Something we've seen in the United States, the FISA court, which was developed supposedly to provide some oversight over data grabbing by the state, has been, we now know, because of Snowden, turned into, kind of perverted and turned inside out by the very agencies it's supposed to be.
Absolutely. I mean, the problems with the IPT are manifold, and you've touched on a few of them there. First of all, if you lose in the IPT, you're just told that you've lost. You're not given the reasons why. Secondly, they can quite often go into closed hearings where you wouldn't know what the outcome of the case is, what the legal arguments are, what the evidence is. And so there hasn't yet been a case which has, well, the IPT very, very rarely upholds any case at all. I mean, the statistics on it are laughable in terms of the number of cases that are upheld. And it doesn't appear to us that the IPT will be able to provide effective oversight. And certainly, if you think about what Snowden has revealed, the fact that this is happening is evidence in itself, or should be evidence in itself, that there aren't adequate safeguards in place. And that those safeguards are in terms of parliamentary scrutiny, in terms of the IPT, and in terms of the legislation. Overall, we would say that the protections are not adequate. There are two types of surveillance that I think it's worth kind of splitting this into to understand the background to it. Overt surveillance and covert surveillance. In relation to overt surveillance, so where someone knows that they're being monitored, they understand that the police are watching them and they want to do something about that to challenge it, for example, John Cat, or the overt retention of data about them, for example, in the case of GC. Challenges have been possible through judicial review and through the higher courts. GC was one where the Supreme Court ruled that the government's database was unlawful and followed the ruling in Marper in Strasbourg. Now, in relation to overt surveillance, there are still hurdles in terms of being able to pursue a case. It's still difficult. Someone needs to know that they're being watched and then find someone who's able to take the case for them. And obviously, there are the usual problems in pursuing any kind of litigation with financial considerations, whether they qualify for legal aid, which is being restricted even more. So there are those considerations which are a problem. When it comes to covert surveillance, the situation is much, much worse because quite often the government will adopt a neither confirm nor deny policy. And so they will neither confirm nor deny that this is actually happening, as they've done in relation to our case in the Investigatory Powers Tribunal. In those circumstances, the government will see NCND, as it's known, neither confirm nor deny, as a rule as opposed to a policy. So they'll blindly follow it, it seems, even where it's obvious that this kind of thing is happening, as in with the Snowden allegations. I mean, those documents have been relied upon in other jurisdictions. Other governments have been happy to either confirm or deny that they're correct, but our government is adopting a very strict neither confirm nor deny policy, which doesn't allow there to be effective oversight.
Or a public discussion.
Or a public discussion. So it's frustrating the ability of all of us to have a proper, full and frank discussion from a position of knowledge. And if we're not adequately informed about what the powers are, what technological powers exist, how they're being used and why they're being used, how can there be a full debate about whether or not there is too much data grabbing going on the part of the state and the implications this has? I mean, I think particularly in relation to the case against GCHQ and the security services, had it not been for Edward Snowden and his leaks and the media outlets publishing those documents, I cannot see any other way that we would have found out about this happening. In most cases, because of the neither confirm nor deny policy on the part of the state in relation to undercover operations or covert surveillance, it's been because of whistleblowers and the media that these matters have come to light. If we take another example, undercover policing and the way in which undercover police officers have infiltrated protest movements in the UK, even peaceful protest movements. Had it not been for those undercover officers coming out and saying that what they had done, we would not have known what had happened, because someone would have had a suspicion that they'd been under surveillance, and then it would have either gone to the Investigatory Powers Tribunal, where we've already talked about the deficiencies within that process, or even in ordinary public law proceedings, the government would simply say, we neither confirm or deny that there was an undercover officer there. That's it.
And in the example of it going to the Investigatory Powers Tribunal, if, hypothetically speaking, someone had had a suspicion they'd been under surveillance and maybe even an undercover officer had had a relationship with them or whatever, they could have, in theory, gone to the Investigatory Powers Tribunal. The Investigatory Powers Tribunal may even have found that what they were saying was true, but would still have ruled that it would be against national security for that information to be publicly
Absolutely.
released.
Yeah.
So,
Or could have even ruled that it was in accordance with the law, with reference to whatever arguments the government puts forward as to the legislative provisions it was relying upon within RIPA, for example, or the Human Rights Act. And so in those circumstances, we can't expect there to be a full and adequate hearing of any cases of this nature without the role of the media and whistleblowers. Well, again, it comes back to neither confirm nor deny. And at the moment, as long as the government adopts that policy and treats it as a rule, as opposed to a policy that it can depart from, we're not going to be able to have a full and open debate. We in civil society can debate it on the basis of information that's been leaked, but if there isn't an official acknowledgement that these technologies exist and how they're being used, I can't see how there can be a full debate, including the government. There will be a time when, because of this application of neither confirm nor deny, we all know something is happening. We all take a view that it's wrong, for example. The government will still continue doing what it's doing, and there will be a divergence between what we believe is right and what should happen and what is actually happening, which will eventually become untenable, because you can't have any democracy where the government is continuing with a policy which the vast majority of people disagree with, and the government is at the same time stifling any debate about that policy as well.
So NCND is, because we can imagine some kind of legitimate national security context in which neither confirm nor deny might be understandable and might be
absolutely.
But what you're saying is that this policy is being abused.
It's being used it's being treated as an obligation that the state is obliged to neither confirm nor deny all of these. Exactly. Anything which is to do with covert surveillance, as opposed to thinking, well, hang on, this allegation has been made. It's not against any particular individual. It's in relation to a technology that exists and its capabilities. It doesn't. It's not necessary, in our view, for them to maintain neither confirm nor deny in those circumstances. You can see a situation where, say, somebody is a terrorist and they're about to plant a bomb and they want to know whether they're under surveillance. Obviously, there'll be a legitimate reason for neither confirm nor deny. And I don't think anyone disputes that in certain circumstances there will be secrecy, but it's a matter of how that's applied, and whether it's applied on a blanket basis which stifles any debate, which is what's happening at the moment, or whether it's applied in an individual case where there is a specific national security requirement for that to happen.